Welcome to Sakshi TV special and live immigration show with attorney Ms. Sheela Murthy from Murthy Law Firms. This show is scheduled live every Tuesday at 3 p.m. EST. Please call the number on the screen to ask your questions. If you are an immigration attorney and would like to join our immigration talk shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note down the information provided on this show is not legal advice. Use of the content is for general information purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for the use of information as a legal advice. If you need special legal advice, please contact attorney directly. Today, we will be discussing latest updates with the USCIS, DOL, and DOS and ask a few questions about it. As always, please call the number on the screen if you need to speak with the attorney. For consultations, please log on to murthy.com to get help with your specific cases. Welcome, Ms. Murthy. How are you today?
Very good afternoon to you, Swarna, and to all in the audience. Thank you for the honor and privilege of being with you all today.
Thank you. Thank you so much. So, Ms. Murthy, what are the general updates from the USCIS, DOL, and DOS, which handles consultants?
Thank you, Swarna. I know generally I just give a brief update on Murthy Law Firm, but like I think Ranjit always says, everybody knows Murthy.com and Murthy Law Firm. But one of the things that we do on Murthy.com, of course, is provide lots and lots of valuable, free, cutting-edge information with the latest changes that are occurring with the U.S. Department of Labor, U.S. Department of State, U.S. Department of Homeland Security, USCIS. So this half an hour may not be enough to answer all of your questions for the audience, but on Murthy.com, we provide a lot of valuable and free information that you can take advantage of. For example, the weekly Murthy chat, the weekly Murthy forum, the weekly live questions and answers that we answer, the monthly teleconference calls. So we invest literally thousands and thousands of dollars in attorney time every single week in order to help to educate, empower, and enlighten you all as immigrants going through the process. So, Swarna, to answer your question about what are the latest changes. So there's been a lot going on. A few weeks ago, we had the American Immigration Lawyers Association annual conference with senior officials from all of the different agencies, from Customs and Border Protection, from USCIS, from CBP, from Department of Labor, etc. And a lot of those updates we have already shared with you and posted some information on the website. We also talked about it in the last few weeks. The latest that I heard today was that the Dallas, those who are sending any type of filings or paperwork to the Dallas lockbox, in Dallas, Texas, they are having some kind of rejections or receipt notices or delays or problems. The American Immigration Lawyers Association has contacted USCIS to update them of the problem and to get the answers to the solutions, because a lot of employers, individuals, families, and attorneys are seeming to be dealing with this latest challenge as of today, June 29th of 2021.
Oh, okay. Ms. Murthy, before we go to the next question, we have a caller, Chandra from Houston.
Hi, Chandra. Hello. Please go ahead. Chandra, are you there?
Yeah, I'm there. Hello.
Yeah, please go ahead.
Hello. Hey,
hi. We can hear you.
My name is Chandra. I'm calling from Boston. My 6 years of H1B is completed on May 27th, 2021. Actually, my old H1B approval was still only till April 30th, and I have 27 days more. So my employer filed an H1B extension for the 27 days. And when the case was pending, I moved to B1 because till 27th we don't have any update, and I moved to B2 after 27th. And now my 140 is filed under premium processing and it's under pending case. So once my 140 has been approved, can I convert or amend the pending H1B petition for the new duration?
One cannot do it because the USCIS in these types of cases, Chandra, has made it very clear. In fact, there was another case, I think, as of a few days back, where the person tried to argue that it should be an extension, but the USCIS said, no, your prior status expired in this example, on May 27th of 2021, we're already in the end of June. We don't know when you'll get your, I-140 approval. So if it is pending, you're not eligible for the 3-year H1 extension. But based on your B2 change of status, Chandra, that is pending with USCIS, the employer would be able to file under premium processing with a photocopy of the I-140 approval to request a full 3 years of H-1B extension of status for you and H-4 for your family members if they also had filed B-2 as a gap as a protection status to maintain some valid non-immigrant status in the US. But it cannot be filed as an extension because your prior status for your full 6 years, including the 27 days recaptured for time abroad, etc., expired on May 27th. After that, you have to be on B2 and then again file a change of status based on the new I-140 approval, valid for full 3 years based on the AC-21 law and the law that allows you to file the H-1 extensions based on the I-140 approval. But you would have to have stopped working on May 27th and you can restart only when the H-1B with the change of status has been approved for you, Chandra. Hope this is helpful. I'm hoping you're
27th. Yeah, sorry, ma'am. I stopped working from 27th and I moved to B2. So we have to make a change of status from B2 to H1, right? So, ma'am, one
Correct.
question: what would be my pending H1B?
That will stay. That even if it gets approved, it'll only be valid till May 27th because that's all you were eligible under the law, Chandra. So that stays as it is. There's nothing to do with that. Hopefully it'll be approved. If it's not approved, then the problem is your B2 change of status also will not get approved because that is called the bridge status. And if the B2 does not get approved, then the change from B2 to H1B, that change of status with the I-94 card attached to the bottom of your approval notice also cannot be approved for you, Chandra. Hope that was helpful.
All right. Okay. Ms. Murthy, we have another caller, Raj from Texas.
Hi, Ms. Murthy. How are you?
Hi, Raj. Good to see you. Please ask your question.
Yeah. So my question is, I've been working for this company X, and then this company has again another company involved Y, which directly kind of pays X, and then I eventually work for client Z. So let's say the client Z wants me to bring on board and wants to offer a full-time position with me. And will that be any violation kind of stuff with X?
So I don't know what agreements or contracts that may exist between X and Y and what you may have signed with any of these different entities, because those may also come into play. Besides, remember with employment law, Raj, you have federal employment law issues and then you have state employment law issues. So as an immigration lawyer, I'm only allowed to talk about federal immigration law related issues. We are not allowed to give legal opinion on Texas law or California law or any other state law in the United States, because of course I am admitted as an attorney. I was admitted in New York State and now Maryland, but we are allowed to practice US federal immigration law anywhere in the United States. So leave out state law issues. If it's purely federal related issue, it depends on any agreement or contract, as well as state considerations that you have to consider on whether there will be potential roadblocks to prevent you from switching or doing certain things. In general, there is something called in employment law, freedoms, any type of restrictive covenant, which means any restrictions placed by the employer or any intermediate client or consulting company, etc., is viewed very narrowly and strictly by courts because they believe in the freedom of movement of individuals and people to seek out the best jobs to feed and support themselves and their families. So again, it's one of those questions no one can give you a specific unless you hire a local attorney to actually look at it and also confirm that you haven't signed any type of agreement, Raj, that restricts you in any way, because many people sign agreements with the employer agreeing that they will not join another company, or they will give 60 or 90 days notice, or they won't join the client, etc. So there are lots of restrictions. So be careful.
Case is Y the client or is Z the client?
I'm not able to give case specific advice at this point because I'm not even sure I fully understand it, Raj. But whoever is the client, ultimately that definition, depending on if you have a restrictive covenant, you've already signed an agreement with your employer saying, I won't join the client, and you have client one, and that client one introduces you or somehow gets you in touch with client two. If your employer, whoever you have in a restrictive agreement with or that you've signed, could potentially try to sue you in this example, if they feel there's been a violation, because they want to set an example for other people as well, not to do the same thing. So I'm not even able to fully understand. And as Swarna explained at the start of this, they cannot be exact case specific advice because this is meant to be sort of more generic and general to benefit you and everybody else who's in a similar position to understand what the law is and how to think. So if you say, is this the lawyer? Is it A or B or C? Unless I really examine it carefully for you, I don't want to make a mistake and mess up your life with such an important decision, Raj. Thank you.
All right. We have our next caller, Krishna from Florida.
Hi, Ms.
Hi, Krishna.
Sheela Murthy. We really appreciate. Hello, Ms. Sheela Murthy. We really appreciate the time you've been putting for us. This time we really appreciate that. I have a question. My priority date is September 30 under EB2 category. And my question is, I have not downgraded or anything like that so far. My question is, I have two questions. My first question is, does it make sense for me to basically choose the downgrade option on a downgrade to EB3 at this time? And then my second question is, even if I choose to downgrade, is that something you recommend, or when we go to interfile and stuff like that on EB2 140, is it going to slow down the process or anything like that? I just want to know what's your recommendation, ma'am.
Okay, so again, Krishna, like I said before to Raj, right before this call, in your specific situation, I don't know, unless we sit down and spend 15, 20, 30 minutes really looking at what is your specific problem or situation. What are the risks? Are you about to lose your job? Do you have children who are aging out, teenagers that you need to file? You said your priority date is September 30th, but you didn't give me a year. So again, I don't know that it makes a huge difference. It matters because in terms of planning purposes, but in general, the philosophy is, if you are able to file the I-485 for yourself and all your family members with the ability to file the employment authorization document or EAD, Krishna, along with the advance parole, obviously the benefit is that even if later on the dates retrogress and go back years and years, your 485 is filed. That way, if you lose your job, your company shuts down, you leave the whatever the zillion problems in life that we can't foresee everything. There's some benefit to filing the 485, which is a big part of the reason many people decided to take the risk and do a downgrade application from EB2 to EB3. And along with the downgrade application, they filed the I-485 with the EAD and AP. Now, the questions, of course, that arise are, will USCIS approve the EB3 case? We are starting to get approvals and see approvals, but of course, that's not a guarantee because they're revisiting the entire issue. Whereas with the EB2, you already have an EB2 I-140 that is approved and ready to go. So that's one concern. Some people are saying, according to Charlie Oppenheim of the US Department of State Visa Immigrant Control Unit, the person in charge in the country for moving the priority dates based on information that the USCIS gives them, his prediction is that the priority dates will move rapidly in both EB2 and EB3, but EB2 is expected to move a little bit faster than EB3 due to a variety of reasons, including the fact that so many thousands and thousands of Indian citizens, Indian nationals, did the downgrade application from EB2 to EB3. And because of that, what could end up happening is that EB2 could end up moving a little bit faster than EB3, even though right now EB3 is ahead of EB2. So if you have children that are becoming, 21 and you're nervous about them, or you have a particular concern and you just need to file the 485, which is generally a good idea. So everything depends on your particular background and situation in order for me, Krishna, to make a specific recommendation to you as a person, as opposed to generically and generally. It's like, what do they say? A bird in hand is better than two in the bush. Just filing your 485 with the EAD and AP has that advantage. So, because now, even if you lose your job, the economy goes crazy back to some kind of crisis, at least by filing the 485, you're eligible for an unrestricted EAD card instead of being at the mercy of an employer who is agreeing or willing to file an H-1B petition for you, Krishna. I hope this was helpful in terms of general information. I can't give, again, advice unless we really look under the magnifying glass or microscope and look at your background, your situation, your circumstances, and the risks of what we see with you, with your current employer, etc., to make a clear recommendation to you, Krishna.
All right. Thank you, Krishna, for calling. So, Ms. Murthy, let's go back to our questions. Let's start with our first topic, as Charlie from DOS stated about not much retrogression with the green card visa numbers for employment-based petitions until September 2021. What's your thought and predictions about this?
So even Charlie Oppenheim, who has been doing it for almost 30 years with the Department of State Visa Office, when you ask him for predictions, he tells you what is going to happen for the next month. Like in the middle of June, he will tell us for July, or if you contact him now, he may give it to us for August, what will happen, but even he who has been doing this full time as his job for 30 years will tell you that nobody can give you a guarantee of the predictions, because as we all joke, if everybody could predict the future, then you would just buy a lottery ticket for, $100 million or $1 billion, 300 million and retire. But based on the information that Charlie Oppenheim has given to us from the US Department of State, we expect the continuous movement of priority dates to benefit citizens of India, in particular, because of the huge retrogression for Indian nationals, both in EB2 and in EB3. And the big part of it is, of course, because of the presidential proclamations under the prior administration and President Biden continuing some of those, especially for the H-1Bs till March 31st, and the immigrant visa information also, which expired on March 31st, and the H-1B that continued for a couple more months. We do expect that there's been so much underusage, both in the family-based movement of priority dates and the employment-based movement, that we will have all those, 140 or 160,000 extra immigrant visa numbers. Normally each year we get 140,000, which includes family members. Now it is more than double, 280 or up to 292 that we expect to be available for this fiscal year. And whatever we don't use this fiscal year, again, will sort of roll over to the next fiscal year. Plus, there is talk of Congress introducing some type of legislation to recapture the unused immigrant visa numbers for the last 10 or 15 years, to recapture all of those, to make them available, so that retrogressed countries like India and China, etc., will have all these extra immigrant visa numbers, so that the priority dates will keep moving. We do expect a big jump forward in October 2021, like last year, because, of course, as many of you may know, it is the start of the USCIS fiscal year. USCIS fiscal year for Department of Homeland Security and USCIS starts on October 1st and goes till September 30th. So when the new visa numbers the new quota is available, it will jump forward. Now, I know based on last year, and they did not expect so many tens of thousands of applications to be filed, they may move it a little more carefully, but the goal is to keep on moving the numbers, because there is so many unused immigrant visa numbers that need to be used up before each fiscal year. Hope that was helpful, Swarna.
Yeah, it is. You covered all the points. So, since there have been a lot of EB3 downgrades, do you think EB2 is going to move forward? As you're aware, like 10 years ago, aspirants upgraded to EB2 from EB3, resulting in retrogradation.
Yeah, that's as I just explained a few minutes ago with the prior caller. We do expect that EB2 will continue to move forward. At least that is what Charlie Oppenheim has already shared with us, that he expects EB2 to move. Now, USCIS has explained to us very recently, maybe last week, that they do not put the downgrade cases in EB3 category yet until and unless they actually approve that I-140 under the EB3 category, then they count it as an EB3 case, because they don't want to count one person with both EB2 and EB3 under both categories. They want to make sure that they're doing it in a manner that does not double count the people. So USCIS explained that only when they finally approve the I-140, they will then be able to decide and put that person in that particular category. So yes, to answer the specific question, we do expect EB2 to move faster because of so many tens of thousands of people being eligible under the EB3 category for India. And those who have done the downgrade may again have to do an upgrade or do an interfiling, etc., which is again adding one more layer because it's like waves. So many thousands of people are doing the exact same thing.
Yeah. So, what is the spring 2021 regularity agenda by Biden administration? Also, what are the items that are withdrawn by Biden administration, like modernization of H-1Bs, premium process to H-4 EADs, removing public charge rules?
So in the beginning of the start of Biden administration, we actually talked about what his agenda was. Remember, on the very first day he came in office, this is the only time that I remember in 35 years that I've been in the United States and over 30 years been practicing immigration law, Swarna, that a president on day one introduced legislation so directly connected with immigration. And a lot of the things he said was they removed the public charge restrictions. They talked about removing the presidential proclamations, though he did not remove it for H-1Bs, he removed it for immigrants when the prior president's proclamations expired for immigrant visas. He has introduced the USA Citizenship Act of 2021, where they want to try to recapture all the unused immigrant visa numbers from prior years and make it available so that cases can move forward. They've also talked about the elimination of the per country quota limit, which, as you know, exists for Indians, which is a big part of the reason we have such a huge backlog. The per country quota limits, for anybody who doesn't understand what that means, is every country has a maximum number of immigrant visas based on worldwide population and usage, where they cannot exceed a certain number. And that is a big part of the reason, because, for example, India, with a huge population, such a big country with over 1 billion people, gets the same maximum number as maybe Bangladesh or Pakistan or Sri Lanka, etc. So obviously those countries with a much smaller population are less impacted with huge backlogs like we are with India. So, Biden administration has done a lot of things pro-immigration and pro-immigrant, especially compared to the very anti-immigrant mentality of the prior administration, even though 2 out of his 3 wives were immigrants themselves. His mother was an immigrant from Scotland for the prior president, and his father's side ancestors all came from different parts of Eastern Europe. But it was interesting how he blamed immigrants for every problem that existed in America, compared to Biden, whose goal is we recognize and appreciate and embrace the notion that America is a nation of immigrants. We need immigrants for the strength and vitality of America, and we will take care of every person working in America, includes H-1B workers, L-1 workers, and other foreign nationals, as opposed to creating a them versus us, like a rift between people who are all doing good, hard work, paying their taxes and trying to help America. So I think the overall feeling that we have already seen in just last 4 months, it's January, February, March, April, May, June, 5 months of the Biden administration, is we're seeing what a big difference in the mentality, in the attitude. And of course, we spoke with Alejandro Mayorkas, the new Department of Homeland Security Secretary, during the ALA Immigration Conference. He was also the head of USCIS under the Obama administration, and he himself is an immigrant from Cuba. And you can see that their attitude is completely different and a much needed breath of fresh air for all of us, because truly the greatness, I think, of America lies in embracing and recognizing that we're a nation of immigrants, bringing the best and brightest from around the world, making America stronger, making us a world leader in technology, music, art, every other field, because almost whether it's the tech billionaires who started the tech companies or musicians or artists or scientists or Nobel Prize winners, majority of them, in fact, about 50% of the Nobel Prize winners in STEM fields, science, technology, and engineering and math, are foreign born. So what other proof do we need of the greatness of America as a nation of immigrants?
Yes, it is true. It is true. So I want to ask you one popular question, Ms. Murthy, on the process of I-140. If an employer has withdrawn the I-140, can they use the old perm to file a new I-140, or they need to file perm from scratch, assuming the perm was not withdrawn?
If it is with the same employer, not a new employer, if you're trying to use a perm with employer A to file I-140 with employer B, not possible. If you are asking, the question is perm approval with employer A, I-140 approval with employer A, you quit that job, employer A revoked the I-140 petition. Now you want to join back the same company A, not company B, then company A can refile a fresh new I-140 using the same old perm, because it is same employer, same employee, same all data, and do a new I-140 petition for the same company A, for the same employee, in the same category in which it was withdrawn, saying we wish to refile this case because the employee is planning to join us back, or whatever the reason.
Awesome. Thank you so much, Ms. Murthy, for clarifying all the questions. This is Swarna signing off. You're watching Telugu Prajala Mana Sakshi TV. Namaste.